Good afternoon, everybody. Lovely to see you all here. And welcome to this BASW webinar on the Illegal Migration Act and the Nationality and Borders Bill. The Illegal Migration Act erodes the rights of unaccompanied asylum-seeking children, both as children and as asylum seekers. And both pieces of legislation have significant impact on social work practice with unaccompanied asylum-seeking children. I'm Luke Gagan, I'm Head of Policy and Research at BASW, and joining me today to share their expertise on this are Jo Schofield, who is a social worker and a Director of Immigration Social Work Services, Kerry Prince, who's the BASW lead for public and political affairs, and Karma Patrichenko, senior policy analyst at the Refugee Council. We'll be taking questions, so do drop those in the chat box, but be aware that depending on time, we may not be able to answer them all. We'll also today be formally launching the BASW Age Assessment Practice Guide, so do stay on the webinar because we'll be doing that at the end. And the session is being recorded and will be uploaded. So we've got the three presentations, then we've got time for answering questions. And first off the block is Jo. Over to you.
Thank you, Luke. I'm just going to, if it's okay, I'm going to share my screen with a slideshow. Okay, so good afternoon, everybody. Thank you for that introduction, Luke. My name is Jo Schofield, and I am an independent social worker specialising in the field of immigration-based social work. As Luke mentioned, I own my own private social work company. And we work up and down the country with local authorities and social workers across the whole of the UK and Europe. I'd like to just do a very quick note on terminology before we start. So we're talking about unaccompanied asylum-seeking children, who by definition is a child who is claiming asylum in their own right, who is separated from both parents and who is not being cared for by an adult who in law or by custom has a responsibility to do so. Now, whilst we all understand the term US, as an organisation, we prefer to use the term separated migrant young person or separated migrant child, as this reflects some of the conversations we have with young people who feel quite strongly that they don't like the term unaccompanied because it feels like there's a sense of being abandoned by parents, where they feel quite strongly that actually they've not been abandoned or left unaccompanied by their parents, but actually they have become separated through circumstances outside of their control. Under Section 17 of the Children Act 1989, this places a general duty on every local authority to safeguard and promote the welfare of children in need within their area by providing services appropriate to those needs, regardless of immigration status. So this is where services fall for our separated migrant young people. They require accommodation and support under Section 20 of the Children Act and become looked after children from this point, having the same rights and entitlements as their citizen looked after peers. Social workers, as part of local authorities, are responsible for discharging this duty to safeguard and promote the welfare of all these children. Our work falls under the statutory guidance, care of unaccompanied migrant children and child victims of modern slavery. As a result, we are required to receive training on the care and safeguarding needs of separated migrant children and young people. We should have an understanding of the common experiences of this cohort and factor this into care planning. It's not enough to treat separated migrant young people in the same way as their citizen peers. And I personally would argue they have needs above and beyond our regular child and care population, most notably as a result of pre and during migration experiences, as well as a lack of immigration status in the UK that leaves them without permanency. As a result, we have to ensure that young people can access quality legal advice to regularise their immigration status, whilst at the same time working within a multi-agency framework to ensure all of these needs are met. In addition to that, the other role that we have in this work is undertaking age assessments. At present, it is social workers who are responsible for completing age assessments for age-disputed young people, recognising that the best approach to age estimation is through a holistic approach that analyses evidence from a wide range of sources. Age assessment should not be completed for immigration purposes, but ensuring that children's needs are met and that services are provided to those who are under 18 years of age. When age assessments conclude that someone is over 18 and not entitled to services under the Children Act, they are transferred over to support provided by the Home Office. Age is not simply a number for young people, it's a central part of their identity that's being questioned. After months and sometimes years of arduous migration journeys, having your identity questioned can be the thing that tips young people over the edge. In fact, under the United Nations Conventions on the Rights of the Child, Article 8, this gives a child or young person a right to preserve their identity, and this includes their age and date of birth. The Nationality and Borders Act 2022 and the subsequent Illegal Migration Act 23 places age assessment on a statutory footing, whereas historically we were always working under kind of case law and guidance. I'm going to go through the different points of the legislation because I think it's important that we understand what each clause says, and we'll talk about it in a bit more detail as we go through. So under Section 50 and Section 51 of the Nationality and Borders Act 2022, this legislation established the National Age Assessment Board, or commonly known as the NAB. I think I'm going to leave it up to, I think, Kerry, you might be talking about BASW's position on this later on in the presentation, so I won't focus on that too much. Section 52 of the Nationality and Borders Act confers a power on the Home Secretary to make regulations about the use of scientific methods of age assessment. So again, whereas previously we weren't using scientific age assessments, this new legislation brings that into force. In addition to this, under Section 53 of the same legislation, this confers a power on the Home Secretary to make regulations about how social workers conduct age assessments. So essentially the Home Office telling us how we should be conducting this piece of work. Section 52 of the Illegal Migration Act 2023 further strengthened the Home Secretary's power to make regulations for scientific age assessments. Under Section 52(7), so the subsection of that, what this legislation does is places a duty, and that's really important, places a duty on the decision maker, read social worker, to make a negative credibility finding when someone does not consent to a scientific examination for the purposes of age. Section 52 takes that one step further, and it allows the decision maker, again, read social worker, to assume that someone is an adult if they do not consent to a scientific age assessment. Although not yet published, it is expected that these tests that we're talking about when it comes to scientific age assessments are going to be things such as X-rays and MRIs. Scientific methods of age assessment are presented as a panacea of rigour and certainty. However, the Home Office Independent Scientific Committee has concluded what they describe as biological methods are imprecise. They offer only an estimation to between sort of 3 and 5 years, whereas conversely, a holistic social work-led age assessment can lead to more accuracy in some cases without using medical equipment and resources that are already in short supply. Not only is medical consent overridden, but a person could have any number of reasons for refusing such an assessment, including a lack of understanding of the tests and trauma related to previous experiences of abuse. MRI scanning, for example, can be terrifying for adults, let alone children, and coercing young people into consenting will never be in line with the principles of upholding children's rights, which the UK is well known for. The question of whether the asylum seeker can consent to the medical intervention is completely separate to the question whether he or she is a child, but the legislation fails to make this distinction and therefore fails to respect the rights of children and of adult asylum seekers who may have cognitive impairments or mental health problems. In addition to these measures on age assessment, the Illegal Migration Act 2023 also changes the way in which our asylum system will operate going forward. Under the Illegal Migration Act, there is a duty on the Home Office to conclude that someone arriving through irregular routes, i.e. think kind of back of lorries on small boats, these people will not be eligible for protection through the asylum system and will be vulnerable, well not vulnerable, they will be removed either back to their country of origin or a safe third country. Now, it's important to note that the same duty does not apply to children. However, the Home Secretary retains the power to do so. So although it's not a legislative requirement, they have that power to be able to do it if they so chose. Although we are yet to see how this was going to be enacted, if it's going to be implemented in the way the government intend, this means that young people will be vulnerable to removal at the point they turn 18. The threat of removal at 18 will mean that local authorities are essentially become holding centres of care for young people, and it's well established in our domestic legislation that a lack of permanency damages and harms children, and this understanding is reflected within the public law outline, which we all kind of work under in our normal kind of day-to-day work. When young people are told they're going to be deported at 18, there is no permanency. They'll be operating in crisis mode, making it more difficult to engage in education, integration activities, and packages of support. We know from experience that when there is a threat to permanency, we see young people devising or enacting plans to exit the care system and go underground just before their 18th birthday. This policy change or legislative change is going to leave children and young people at risk of exploitation and abuse, which is not only immoral, going against the principles which the UK prides itself, but is going to cost the taxpayers significant amounts of money in addressing. Instead of supporting young people to become active citizens, we are going to be essentially holding them to become victims of an underground system that will abuse and exploit them. The increase, or challenges, I suppose, for social workers is there is, the increase in hostile environment policies place young people at risk. At the same time, facilitates opportunities for vulnerable adults to claim to be children to avoid harsh treatment. What we see in our practice, and what I'm definitely seeing, and local authorities agree with me, is a direct correlation between recent immigration policies and people being forced to make decisions they may not ordinarily take in order to circumnavigate a hostile environment agenda. In our opinion, far from addressing the issue, we find that these policies exacerbate it, increasing workload for local authorities and increasing suspicion of children who are then more likely to be subject to an age dispute and adultification by the professionals who should be caring for them. In addition to this, there is a conflict in social work values, and this has actually led to some social workers refusing to undertake this work going forward. Another concern that I just sort of want to re-highlight before I conclude my presentation is this idea that how we conduct our work is vulnerable to influence by the Home Office. And as professionals, I feel we really need to push back against this. Thank you for your time. Kerry is now going to provide an update on the political context. If you have any questions, like Luke said, please do put them in the chat box and we'll do our best to answer them at the end of the show. Oh, I've just got to figure out how to stop sharing. Sorry, everybody. This is not my strong point. Can anybody tell me how to do that? Ah, got it. Thanks.
Thanks, Jo. I'm just going to share mine now. I think I froze there, but I'm back. So yeah, my name's Kerry Prince and I'm BASW's Public and Political Affairs Lead. So I'm just going to give some political context about why this has happened, the environment in which this has come about in, and what BASW has been doing about it. So why have these changes happened? So the hostile environment, as Jay referenced a lot in her presentation, really took speed in 2012 with the implementation of policies that were designed to make undocumented migrants feel unwelcome in the UK. You'll know that if you have to engage with a landlord or a doctor or an employer, they are responsible now for checking whether you have the right to be in this country before they engage with you. And this makes it virtually impossible to live in the UK without interacting with a landlord, a doctor or an employer. And if you're not engaging with any of these, you probably live in quite difficult circumstances and are operating under the radar as such. No recourse to public funds was widened, which affected women trying to escape abusive relationships and children's access to free school meals. We saw with the Brexit vote, when the UK voted to leave the European Union, that this paved way for quite a lot of people, members of the public and politicians and commentators, to think that it was fair game to talk negatively about immigrants and asylum seekers and refugees, and because they viewed that that's what they voted for. It's not uncommon, and many will have experienced of talking to someone who said they voted to leave the UK because they wanted to stop immigration, because migrants or asylum seekers or refugees are stealing British jobs, and this has just become worse over time. There's been no real road back on language used by commentators and politicians, and particularly the press. We have elected politicians time and time again, especially over the last 13 years, who have chose to make immigration-related policy the priority. In the last few years in the Home Office, especially, we've seen with Priti Patel and Suella Braverman, legislation and plans and policies and language they use, which is designed to inflame tension and make the UK seem like an undesirable and unwelcome place for asylum seekers to come. And we have seen over many years the media exaggerating and deliberately inflaming tensions to drive this narrative and lead to this legislation. This is just the Daily Express. There are many other papers who take the same approach, but we see headline after headline demonizing asylum seekers, so saying workers are fired for being British, which we know is absolute nonsense, but that really gets into people's minds, and they then believe the idea that asylum seekers are coming over to the UK. They're not actually asylum seekers, and they're stealing jobs, and it's difficult to now live in Britain if you're British, which we know is nonsense, but that is what has happened over the years, which has led to where we are now, which has led to government acts. So the go home bans, are you in the UK illegally? Go home or face arrest. These appeared up under Theresa May as Home Secretary. We've seen middle of the day immigration raids, which have been met with huge protests. And we also are well aware of the horrible conditions that asylum seekers are living in when they do get to the UK, which is heavily and widely documented, both so by organisations with goodwill towards asylum seekers who want to highlight what it is that people are going through, but also by more of the right wing who want to try and dissuade people from coming to the UK in the first place, saying this is what you'll be met with. As Joe's explained, and I'm sure Cameron will go on to explain, there are two key pieces of legislation recently, which are the Legal Migration Act and the Nationality and Borders Act, which have been born, I would say, from media hostility, encouraging politicians that this is the line of action that they should take in order to win elections and win over public favour. So I've been at BASW for 3 years, and certainly, at least in my time and before my time, we've been campaigning against the hostile environment and negative changes to immigration law. So an example for this, we've submitted evidence to Parliament opposing the two pieces of legislation, and we were also invited to give oral evidence to the Joint Committee on Human Rights. BASW's voice is being heard by politicians throughout Parliament and the civil service. We joined up with the Refugee Council and other organisations to communicate with parliamentarians about the changes, and particularly the impact of these changes on unaccompanied asylum-seeking children, for whom social workers have responsibilities. We've kept the pressure on the government by writing to them, and through engagement with the Age Estimation Scientific Advisory Committee, we have made clear that we don't believe scientific methods or biological methods, the term is interchangeable, are the best way to handle age disputes of young people who travel to the UK. We have released statements encouraging BASW members to not work for the the National Age Assessment Board, which is a Home Office board. So essentially, you'd be employed by the Home Office. This didn't make the Home Office very happy, and we were cited as being one of the reasons why they've had such low uptake in social workers wanting to join the board. But we have tried, and we've worked, and we've joined coalitions of other organisations, such as the brilliant work that the Refugee Council do, to change the government's policy drives. But this is difficult because they have a majority. It's not as if we can just pluck off a few Conservative MPs and get them to change their minds. This is what many Conservative MPs think what the country wants. And it's very challenging to get them to row back on this. We have the courts, who I'm sure Kama will go into, making a lot of progress in challenging the government, but that raises tensions even more, and pushes the government as well to want to introduce tougher legislation. So we can't, because these are the laws, social workers can't just reject them. They can't just say, well, we're not going to do that. Can we boycott them? That's simply not possible. But what we are doing is looking how we can work with the next government to repeal the Act, especially the Legal Migration Act, and bin the policies completely. And so with an election probably within the next 12 months, that's what BAS will be focusing on, trying to get the next government, probably a Labour government, to adopt a different approach and listen to us and other organisations about how a hostile environment actually makes things worse for everyone. And that is it. Quite brief. I don't know how to stop my screen. Oh, there it is. And now it's over to Kama.
Thank you so much. Hi, everyone. I will also try to share my presentation with you. My name is Kama. I work at the Refugee Council. We are a national refugee charity, and we've been established in 1951 in response to the Refugee Convention. And we are just basically doing what our name indicates. We provide services to people seeking protection in the UK, to men, women, children, and families. And we also do advocacy and influencing work. So I will try to cover a few points, trying not to repeat what Joe and Kerry covered so brilliantly in their presentations. But I will touch a little bit on the IMA, so the Illegal Migration Act, and these key provisions that are within the Act. And I will try to outline where we are today and what's the direction of travel. I will very briefly touch on recent two legal developments that both Joe and Kerry mentioned, which is the High Court decision on the use of hotels by the Home Office to accommodate separated children, and the Supreme Court decision on Rwanda from last week, and just then summarize really quickly key concerns and challenges that lie ahead of us, which again, will be echoing a lot what Joe and Kerry already said. So before I start, I really want to say a huge thank you to all of you supporting some of the most vulnerable children in the country and doing really brilliant work and being here today to just expand your knowledge, and to fantastic work that the British Association of Social Workers have been doing. And we are really privileged to be working together with Kerry and Luke, particularly during the passage of the illegal migration bill as it was then, and having support from the association has been vital in informing decision makers about the negative consequences that the piece of legislation they are about to pass is going to create for social workers, for children, and for everyone really involved in supporting people seeking safety in the UK. So as you may know, the bill was introduced by the Home Secretary in March this year, and it went through an extremely quick parliamentary procedure. It's quite unprecedented for the piece of legislation of such depth and scope to be, to get royal assent just a few months after it has been introduced. But it is now the law of the land. However, what I want to make clear is that the majority of provisions in the Illegal Migration Act are not yet in force. And the concerning element that, is a challenge for us, as I imagine is a challenge for you as social workers, is that we don't really know how the government, practically speaking, is going to operationalize many of these provisions. And that's concerning because these provisions are really quite substantive, and they are radically changing our approach to managing asylum claims from people coming to the UK. So it's really vital that we have the certainty from the government around the operation. But because the Act is so regressive, even we believe the government, the Home Office in particular, are finding it quite difficult to implement and really tell us what they are going to do in relation to realizing different bits of the Illegal Migration Act. One thing I want to flag, and I will not be going through all the points on the slides you are seeing now, is that we believe, as Joe and Kerry was saying, that this piece of legislation is regressive. It significantly undermines the laws we already have, both our domestic laws and statutory guidance, as well as the international laws that we are complying with, the UN Convention on the Rights of the Child and significantly the 1951 Refugee Convention. We are taking steps back and actually not resolving issues that and challenges we are facing as a country because of the increase in forced migration, but we are actually creating bottlenecks and creating a system that will be just more hostile and unworkable and even more costly. So by government's own admission, it is more than likely that the provisions in the Illegal Migration Act will be in contravention of our obligations under the UK human rights legislation, and that's quite significant and something to bear in mind. So I want to talk about 3 provisions very briefly that are cornerstones of this legislation, which is inadmissibility, detention and removals. And then I want to focus on the new powers that the Home Secretary is going to assume at some point in the future, which will interact with support that local authorities are providing to children under the Children Act. So really quickly on inadmissibility. Inadmissibility is a process whereby someone comes to the UK and wishes to claim asylum, but their claim for asylum is not going to be accepted in the UK. And I think Luke already said that what the Illegal Migration Act is doing is effectively extinguishing people's ability to claim asylum in the UK if they fall under one of the 4 categories that are defined in Article 2 of the Illegal Migration Act. And you can see these conditions listed on a slide. The reason why we are so concerned is because effectively we will be turning away people who have a strong claim for asylum, people who are fleeing to the UK to escape persecution, war, discrimination, and are de facto refugees. And we actually did an analysis as the Refugee Council. And according to our analysis of the Home Office on data, looking at people who are crossing the boat, 3 in every 4 of those people would be recognized, would be confirmed to be a refugee if the UK government processed their asylum application. So what it means that we are just effectively preventing people from claiming asylum in the UK when they very likely have strong claims to seek protection here. So in terms of detention and removals, and colleagues talked about this already, there is a duty placed on the Home Secretary in the Illegal Migration Act to remove anyone who would fall under these 4 categories in the Illegal Migration Act. So people arriving through irregular means, not having permission to enter and stay in the UK. And whilst there is an exception from that duty in relation to separated children, this is just a temporary exception, and Joe already covered this point, so just to reiterate, a child who is separated and under 18 can still be removed by the Home Secretary under the provisions of the Illegal Migration Act, but it is a power rather than a duty for him to take these steps. So a child, there's no obligation on the Home Secretary to make sure that a child under 18 is removed, but such possibility exists. And then the moment they turn 18, the duty to remove them kicks in, and they are most likely going to be removed, providing that there are places that they can be removed to, which brings me to my second bullet point, which is a provision around a list of countries from which asylum claims would not be accepted because they are deemed to be safe countries. And recently, India and Turkey were added to that list. And that's really concerning because we are getting asylum claims from both children and adults from these countries, and they are getting their asylum claims upheld and are recognized as refugees. And obviously there is also a concept of removing people to a safe third country where their asylum claims could be decided. And at the moment, the only agreement of such kind that the UK government has in place is with the government of Rwanda. And I will get to the Supreme Court decision, so we will talk about this a little bit more. So the powers to detain are quite extensive, and I really want to make it clear that they apply to children as well. And anyone who will be detained under the Illegal Migration Act will be detained for at least 28 days before they can apply for bail. There are some exceptions around children who are detained with the view to remove them, where they would be able to apply for bail after 8 days, but effectively, you know, the majority of people will be subjected to at least 28 days of detention. And one last point I want to make in relation to detention, because obviously that's the environment you in the future most likely will be interacting with when you have a child in your care and they are being taken away and placed in detention, is that the duty to consult the independent family returns panel when a child is about to be detained or removed from the UK is being disapplied in Illegal Migration Act through Article 14. What you might be interested now to hear a little bit more, because this is an area that would directly interact with your work on daily basis. Again, once these provisions are in force, at the moment they are on the statute, but they have not been implemented. Are new powers in Article 16 to 21 in relation to the Home Secretary power around the rights of separated children who are in need. So children who would be, you know, in care with local authorities under the Children Act. So I am not going to go through all of these articles one by one. You have the information here if you want to investigate it further. But I think there are 3 potential areas that I really want to draw your attention to. So the first one is Article 16, which gives the power to Home Secretary to directly provide accommodation to children who otherwise would be supported by local authorities under provisions of the Children Act. So that's, you know, a very concerning development. And I will touch on this point a little bit in a moment when we talk about the recent High Court decision in relation to the use of Home Office hotels. That's really concerning power, because we are yet to understand how this power conferred in Article 16 would sit alongside provisions that local authorities have under Section 17 and Section 20 of the Children Act. And then another article that I really want to highlight to you is Article 17, which gives Home Secretary power to request a child from local authority care into her care. And again, we have so little information beyond what's really on the slide about how it would work in practice. And that's a really important area for us to continue to press the government on, to try to understand how they are intending to make this provision operational. And lastly, Article 18, which places a duty on local authorities to share information about children in their care in any format that Home Secretary deems necessary and appropriate. And that's really concerning because, you know, as practitioners, you know better than I do how important it is to have a relationship of trust with children you support, especially, you know, children who are at risk of trafficking and exploitation. What really concerns us that this relationship of trust will be significantly undermined by Article 18. And I can easily imagine situations where children would not feel compelled or comfortable to really share information with you if they know that you are under obligation to then pass this information to the Home Office. So this vital firewall and trust that so many of you are working so hard to create with a child you are looking after, you're responsible for, can be quite easily destroyed by that provision. So in terms of legal developments, just again, in a nutshell, we had 2 important decisions that I think you should be aware of, although I appreciate that probably many of you are really familiar with these legal developments anyway. The first one is the High Court decision from July, a ruling on the Home Office use of hotels and the Kent County Council withdrawing from providing support to children in need in their area, to these separated children who were arriving through the channel and, you know, obviously arriving to Dover within the authority of the Kent County Council. So the High Court ruled it unlawful for the Home Office to provide accommodation to this group of children, and for the Kent County Council to withdraw any support that they should be providing to these children under the Children Act. So that's a really important development and a landmark ruling that actually reinforced what we've been saying for, you know, many years now, that these children should enjoy full protection of the Children Act, because the Children Act does not differentiate between, you know, does not create two-tier levels of support based on how child arrived to the UK or the nationality. What the Children Act is looking at is whether, you know, we are dealing with a child in need, and then if we do, specific steps need to be taken by local authorities to promote and safeguard such children. So that's really important, that this kind of a principle of the Children Act, that the cornerstone that the Act is built upon, has been upheld by the High Court. And obviously, as I was saying before, we are yet to see how it would interact with Article 16 of the Illegal Migration Act. And we actually think that the decision from the High Court, which has been quite clear in that sense, will make it much more difficult for the Home Secretary to assume these powers that you know, were conferred through Article 16 of the Illegal Migration Act. And the Supreme Court decision of Rwanda from last week, which, you know, I imagine many of you maybe heard about, it was quite hotly debated in the weeks coming up to the decision. And obviously, once the decision was announced by the Supreme Court last Wednesday, there has been a lot of press coverage. Essentially, what the Supreme Court decided is that the agreement that the Home Office has, well, the UK government has with the government of Rwanda, does not really provide sufficient protections for people in the Rwandan system who would be sent there for their asylum claims to be considered in Rwanda rather than dealt with by the UK. And specifically, the courts found that there is a real risk of expulsion, a concept of non-refoulement, which is enshrined in Article 32 of the Refugee Convention, which in a nutshell says that if you are coming to a country to claim asylum, you cannot be sent to your country of origin, because obviously that undermines the very principle of why you need to flee in the first place. And basically, the Supreme Court found that at the moment, the asylum system in Rwanda is not sufficiently safe and operating well enough to really provide a fair hearing and determination of asylum claims. So that's where we are. What it means for the Illegal Migration Act, it means that it makes it at the moment impossible for the UK government to start sending people to Rwanda whose asylum claims were deemed inadmissible. And what it also means is that it really puts the whole operation of the Illegal Migration Act in question, because at the moment there is no country to which people could be removed. So everyone who arrived from 7th of March up until this point, you know, there is a question mark about the process that they would be going through. And many of these people, including children, are in limbo at the moment. In terms of children specifically, because this is what you may be most interested in, and I didn't mention it before, just want to flag that we believe that children who fall under the provisions of the Illegal Migration Act before they turn 18, they will get a form of interim status from the Home Office that would see them until they turn 18, at which point they will, you know, will not be able to apply for any onward status or settlement in the UK, but there will be an interim status, we believe, that the Home Office will give them until they turn 18. Again, many vital questions are yet to be answered. And the last point I want to make really quickly, and I think I've touched on this already, and colleagues covered these points as well, is that the Illegal Migration Act is significantly undermining our international obligations. And as I've discussed already, there are court decisions and other pieces of domestic law with which the Illegal Migration Act quite clearly is quite incompatible. So we are yet to see how the government is intending to square the circle, so to speak, and how they are intending to bring these provisions into force. In terms of the use of hotels, as we've been saying, it has been confirmed by the High Court that this is a form of unlawful accommodation and unlawful form of supporting children. It does nothing more that creates a two-tier system and actually undermines the provisions of the Children Act. Unfortunately, the Home Office continues to operate hotels, although, as we believe, no children are currently in these hotels. And the case in court is ongoing, so there are further hearings on this case just to ensure the government's compliance with the law. And we are in a quite precarious situation because we have Home Secretary who continues to breach the laws that he should be upholding. And in terms of the Rwanda and future for the Illegal Migration Act, is that we are now expecting the government to put the agreement with Rwanda on the statutory footing and have a treaty with Rwandan government and try to insulate their plans this way and make it harder for the courts to challenge their decision. And also we are expecting yet another asylum bill to be introduced at some point in the next few weeks that would deal with the question that the Supreme Court posted, rightly so, about the poor provisions of the asylum system in Rwanda. And we think that obviously we are speculating, but we think that the government will try to pass primary legislation addressing this point, effectively, disregarding the decision of the Supreme Court. And the last point I want to make, why this is all of these developments, why they are significant. And they are significant not because of how they will impact on your work, how they will impact on children seeking asylum in the UK and on our asylum system, but actually the recent steps that the government is taking following Supreme Court's decision on Rwanda really show that they are undermining the rule of law and trying to circumvent court's decisions by passing primary legislation, which really undermines the way our democratic systems should be functioning. So it is a whistle-stop tour. I hope it was useful, and I see some questions have been popping up in the chat, and I will be happy to answer them. Thank you very much.
Thank you. Karma, one point of clarification, which I think is probably useful to make, is am I right in saying that just because the Rwanda judgment has been overturned, which is the safe third country for the time being, the government can still deport to what it deems to be safe countries? So, for example, many of us will have worked with young Albanian asylum seekers, and Albania is, as I understand it, Karma, now deemed to be a safe country by the government. So young people at 18 will be deported to Albania.
Yes, absolutely. You're right. Look, like Albania is on that list, and now also India and Turkey. So it means that these claims are deemed inadmissible. It may be possible, that there are provisions to challenge such decision, because we have to remember that also each asylum claim should be assessed on their individual merits. But yes, you are right that, broadly speaking, it just makes it easier for the UK government to remove children from Albania, in the example you gave, back to Albania and not consider their asylum claim.
So we've got 3 or 4 questions which I haven't managed to answer in the chat. Shall we take those? And then I'll quickly say something about the age assessment practice guide, and then we'll have to wrap up. Joe, I'll put you in the hot seat. Which law should social workers work with as this conflicts with the Children Act 1989?
Okay, well, we should still be working under the Children Act 1989, and it doesn't remove that responsibility. So my advice to social workers is to continue providing your care and support as you would do for any other looked after child. The new immigration law, it does conflict with the Children Act, I think, but as Karma so beautifully put it, the devil is in the detail. Like we haven't seen how this is yet going to be enacted. We don't know how or whether the Home Office are going to remove children forcibly, for example. We don't know whether, I mean, this is very much a personal opinion, but at the moment they haven't got the systems and structures in place to deport adults. So I don't think they're going to be looking at children immediately, because they've got a lot of work to do. If they want to do what they're trying to achieve. So at the moment, we should always be working under the Children Act. There is other immigration legislation. The Immigration and Asylum Act of 2002, I think, is all like this stuff already exists. It still conflicts. So, you know, when we have young people who are appeals rights exhausted, who are in the care leaver system, for example, we have conflicting legislation there. So we have our Social Work Act and our Children Act and the immigration legislation, and these two clash. Like that someone's entitlement to leaving care services might clash with their entitlement to services under the immigration law. We undertake human rights assessments to work out how we're going to manage that conflict. So the short answer to that is to carry on working under the Children Act and provide those services as we have been doing.
Okay, next question. Rwanda has been blocked. No, sorry, just to ask. Children will be sent to Rwanda if agreed, or only after their 18th birthday. Rwanda has been overturned by the Supreme Court. The government is trying to find a way around that. That doesn't prevent young people at 18 being deported to a safe home country like Albania. Okay. Also conflicts with social work ethics. This legislation contradicts so many arrangements. It contradicts children's rights because it lumps them in with adults. It conflicts with the rights of refugees. I mean, it conflicts with the Human Rights Act. The list just goes on. Will social workers be deployed with children if they are their key workers? We've not seen anything about that. The big point to make is, and which we've been banging on at BASW for the last 2 years, is that none of the, apart from it being impractical, immoral, unethical, illegal, is that a lot of the detail just hasn't been thought through. And it's a complete and utter dog's breakfast. And whoever you talk to is saying this hasn't been thought through. It's not just us. And have you seen any increase in the removal, deportation of young people to date? Karma, do you have any data on that?
Thank you so much. So we are actually not seeing an increase of children who are accepted as children. But what I would like to flag, and obviously Luke will talk more about this, is the issue of age assessment. So when a child, a de facto child, is assessed as being over 18, and we've actually had a child on a flight to Rwanda sitting in this plane that fortunately did not take off last summer because of the flawed assessment at the port of entry by the border force officials. So just my little appeal to all of you to really, and I appreciate how difficult age assessments are, but just bearing in mind that now risks of assessing a child as being an adult are significantly greater, because they would fall under these new provisions on being removed, and what we risk seeing is actually seeing de facto children being removed from the UK. But yeah, just to answer the question, like we are not seeing children being removed yet, but this may change, and we will be monitoring the situation and let you know if that happens.
Okay. yes, somebody's made the point about keeping an eye on what's happening on mainland Europe. Absolutely. There's a query about appropriate adult. Maybe Karma, you can look at that one and respond directly to the person. Before we
Yes.
take any
I will. Thank you.
more questions, I mean, just to say, Joe's going to put our new age assessment practice guide in the chat, right? Age assessment has always been an important part of social work since the Merton Judgment in 2003, I think it was. It's become a lot more important given the legislation that we've been hearing about today. The guide represents best practice, and it also deals with the interface with the Illegal Migration Act, the National Age Assessment Board, and scientific assessment. So it's pretty cutting edge. And about 20 experts, including Joe, worked on that with us. And it's the sort of guide that I wish I had when I was working with unaccompanied asylum-seeking children. So I'd like to thank the Working Party who kind of pulled that together. And Jennifer, your point, Jude made this point earlier, immigration and asylum law is UK-wide, it's not devolved. And so age assessment best practice and the legislation it affects, it interacts with our UK-wide. Okay, running out of time, so I'd just like to thank Joe and Kerry and Karma for a hugely informative session. Thank you all for your questions. I hope we gave you some help and support in dealing with that. And finally, to say, many of you, it's good to see some faces I recognize out there, are BASW members. But if you are not a BASW member, do think about joining us. We have a group that focuses on unaccompanied asylum-seeking children, but there are obviously huge other benefits as well. So thank you very much all for joining us today.